for locals to actually have their say.
Michael Wood.
Very happy to take a call on this part of the bill, part 2. And, Mr Speaker, I'm reminded of a situation I have on the domestic front at the moment. We've debated part 1, which is the entree to the bill. The domestic situation I have at home is that upstairs there's been a bit of a stink. Haven't quite been able to work out what it is. I did a bit of investigation on Sunday morning and found out we've got a blocked drain downstairs full of putrid, fetid water. We found the source of the contamination, and part 2 is the source of the contamination in this bill, because it's the odious part of this bill which does the business of stripping away precious public reserve land from a community that treasures and needs that land. And, Mr Chair, I just want to work through some of the key sections of Part 2, particularly Part 6, with a bit of reflection on some of the very good submissions that were produced and then summarily ignored by the government as this piece of legislation has made its way through the process. And if we read through Part 2, particularly Section 6 and Section 8 as well, which I'll come to, Mr Chair, it's all there in pretty sort of technical and bureaucratic language. But fundamentally what it does is stomp all over community interests and the due process that we normally expect people to be given in this country when major changes are made to their community. It stomps all over provisions that we would usually see enacted through the Resource Management Act and the Reserves Act. And I want to turn to some of the very good submissions we received, sir, that spoke to these points. And the first one was from Auckland Council. And I've got to say, I think this is pretty significant, sir, that we've got Auckland Council, the largest local authority in our country, the unitary authority that was set up by this government, and it is speaking in extremely forceful language about the way in which this bill cuts across what are, quite frankly, pretty close to constitutional arrangements in our country in terms of the relationship between local and central government. Here's what they say first up. They say that the use of special legislation to lift reserve status and provide for housing development outside normal statutory processes sets a concerning precedent. And at points it's called a dangerous precedent. In a formal council submission, sir, that is extremely strong language for a council that needs and wants to have a good relationship with the government to use. And I think that shows the level of alarm in local government about these steps from the government, and we've seen plenty of them over the course of this year. But in this bill, there is indeed a very concerning precedent that we see coming through. Further on in Auckland Council's submission, sir, they go on to talk about the way in which the bill, and in particular Section 6 of the bill, Section 6 of the bill really cuts across the Reserves Act provisions that usually govern any changes to our precious public reserves. And so in the Reserves Act we set a high bar. We deliberately set a high bar for changes to public reserves because they are so important. And they're very important because, generally speaking, once public reserve land is gone, it's gone. So it's extremely important that it's protected and that the community that benefits from it is able to have a real say over those changes and that the interests of the reserves are protected. And what the Auckland Council says in respect of this is that the Reserves Act sets out stringent steps that the Minister of Conservation must follow before revoking the reserve status of part or all of the reserve. And of course it's Section 6 here which by fiat revokes that reserve status of part of Point England Reserve. If that process had been followed in this instance, the Minister would have been required to set out the reasons for the proposed revocation and invite comment from Auckland Council. Public notification of the proposed revocation would have been required. Affected members of the public would have had a right of objection. The Minister would have been obliged to take account of any such objections and would also have been subject to the principles of administrative law. The decision could have been reviewed by the courts. And, sir, I wonder, where is the party of people like Jim Macleay, who once would have stood up for those kind of principles, the principle of the rule of law and due process, and people being able to have a say about these kinds of things? Instead, we have a bill that's going through and is cutting across all of those sorts of rights that people in our community can reasonably expect. The Maungakiki Tamaki Local Board, in its submission, talked on this further, alongside, I think, 5 other local boards, including a number of local boards primarily dominated by National Party members. They have expressed their concern about what they term the dangerous precedent, in line with Auckland Council's comments. They've noticed that there's a fast-track development and it avoids a robust public consultation process including a right of appeal. These are extremely serious concerns from a local board that is the most local form of democracy in this community. Mr Chair.
Michael Wood.
Thank you, Mr Chair. And those concerns have been completely ignored. The local board did a patch-up job by trying to have some local consultation of the kind that the government didn't have when it tried to slip this bill through its early stages over the summer period. And it's actually interesting, Sir, to read in the submission and in the notes of that public meeting the serious concerns of the community, not just about the loss of their reserve, but their concerns that in the future the public reserves of other communities may be taken away by this kind of approach as well, Sir. Continuing through the submissions which point to these very serious process concerns, there's another excellent one from Forest and Bird. And Forest and Bird, they're a serious organisation that for 70 or 80 years has fought for our ecology, has fought for public open spaces. They're not politically partisan, they're interested in the common good, and they're interested in fair and due process as well. And here's what Forest and Bird says. They say of significant concern to Forest and Bird is the removal of the RMA statutory requirements around consultation, public engagement and environmental assessment for subdivisions. And again, Sir, and I'd ask the Minister actually about this, because this comes through in submission after submission, where actually is the environmental assessments that we would expect to see on a piece of public reserve land that has notable environmental and ecological values that have been assessed by a number of experts? We've seen absolutely none of that, Sir. Another submission by Julie Chambers, who's led the Save Point England group and is a person who's very well known in the community for serving the community over many, many years. Long-time National Party member, not anymore, but she makes the point that the inclusion of Section 8, we turn to Section 8 now, forces Auckland Council to carry out a major plan change, and this is a bit which imposes a particular kind of zoning, mixed housing, urban, on the land that will have reserve status revoked, that will convert the use of treated public open space into residential housing. So not only are we taking away the reserve status, then through an Act of Parliament, rather than public consultation, we're also dictating exactly the kind of urban form that will go onto that public land, where across all of the rest of Auckland, we have had a thorough consultative process through the unitary plan to determine what form of housing should go on what site. None of that in the case of Point England, Sir. I want to touch on a couple of the SOPs which go to these points, Sir, as well. Eugenie Sage's SOP number 317, which we fully support, Sir, because it tries to backfill some of the deficiencies of process that are embedded in this bill. And it does that by saying, can we at least ensure that after all of these egregious breaches of process, we can at least have a basic RMA process in terms of the development that will occur on what everyone acknowledges is a sensitive site in many ways. And I think that's the least that the people of the community could expect after having all of their other rights trampled over in this process. I always like contrast, Sir, and in contrast to that good SOP, well, we've got Dr Smith's SOP 321. It's less an SOP and more a doodle on the back of an envelope done over Bellamy's one night, I think, Sir. It is absolutely pathetic. It's about the Minister trying to get an extra 500 votes for Denise Lee in the coming election in that seat, trying to save a few votes for her by banging on an extra playing field on the reserve with absolutely no background work done on that whatsoever. What has the Minister done? This is a question for the Minister and the Chair, actually, to understand Auckland Council Sports Field Development Capacity Project, which actually has worked out on an evidential basis where sports fields should go. What kind of sports field it should be? Should it be a grass turf or an artificial turf or a hybrid turf? Has any of that work been done as Nick Smith put forward this SOP? What engagement has there been with Auckland Council around the open space development strategy, which actually determines the kinds of open space that we want in different places? There is absolutely nothing in this SOP. It is simply not worth the paper that it's written on, and from a public policy point of view, I think even that Minister, Minister Smith, who is responsible for so many cack-handed pieces of legislation, should be ashamed of particular SOP, Sir. Sir, in finishing my comments at this stage, and I'd like to come back and take another call on some of the environmental aspects later on, I do have a couple of questions for the Minister in the Chair, in addition to those ones which I've already offered. And the first one I'd like to ask is, in respect of Section 8 of the bill, can the Minister explain why we wouldn't, once reserve status is revoked, why we wouldn't simply have a plan change process that would be open to public consultation to determine the appropriate form of density and urban form on that site. And I think the people of the community of Point England would like to know that. Thank you, sir.
Phil Twyford.
Chairman, I want to address my comments to